Welcome to Benson on Injury Law.
Welcome back to Benson on Injury Law with attorney Paul Benson. Paul is a personal injury attorney based in Wisconsin who spent the last decade helping people across the state get the compensation they deserve after serious injuries. Paul believes in clear communication, standing up to insurance companies, and making sure regular people are treated fairly. I'm Kevin Rosenquist. Today we're talking about insurance bad faith. Paul will explain what insurance bad faith means and how to respond if your company wrongfully denies or delays a claim. Paul, good to see you again.
Hey, good to see you.
Insurance bad faith. I've never honestly heard of that. What does that mean, particularly as it applies to Wisconsin law?
In its most simple terms, it means an insurance company treating you unfairly. So this only applies to your insurance company. Is the first thing. A lot of people will call me saying an insurance company is treating them poorly, but it's like in a car accident, it's the other driver's insurance company, or in a premises liability case, it's the business's insurance company. They don't owe you any duty, so there's no bad faith against them. But when it's your own insurance company, they do owe you the duty of what's called good faith and fair dealing. So they have to treat your interests the same as if they were their own interests. And if they put their own financial interests ahead of your claim, that's when there's normally a claim for bad faith.
How is an insurer expected to treat its policyholders, and how does it change once they cross that line into bad faith?
So again, they're expected to treat the policyholder as if they are on the same side as them. It's not supposed to be an adversarial process. They are supposed to assist them with the claim, give them all the information they need to be able to make their claim. They have a duty to tell you about timelines. They have a duty to tell you about coverages. They have a duty to tell you about all the things available to you for the policy that you purchased. They can't hide the ball or do anything like that. They can't lowball your claim, and they can't deny a claim unless they have a good faith reason to do that. So if they don't have a rational basis, or if it's not fairly debatable is another term in the case law, then they cannot deny that claim, and they have a duty to pay the claim.
Are there particular red flags that you would advise clients to watch out for if their insurance company isn't being honest or responsive?
Yeah, unreasonable delays, right? So if they're not getting back to you for a long time, weeks at a time, that's definitely an unreasonable delay. Sometimes it could be even days or hours if there's an emergency situation, right? If it's a flood claim or a roof's been blown off your house, something like that, and you need urgent response from your insurance company, then the response time could be even quicker. So unreasonable delays is a big one. If they deny a claim without any explanation of their basis for denying the claim, that's a red flag. If there's a denial without any explanation. If they don't tell you terms in your policy and you later discover them on your own. So if they don't tell you about a time limit, if they don't tell you about an exclusion, if they don't tell you about a rider, an additional coverage that you later discover in your own policy, that's a big red flag.
Do these cases come up often?
Yes, although I would say the insurance companies are good at framing questionable behavior in a way that maybe just skirts beyond bad faith. They're challenging cases to prove. In Wisconsin, you don't just get the insurance company's claims file. In other words, all of their documentation. You normally have to show the court that you've got a pretty good shot at winning your claim, that there's some good evidence of that bad faith before you can even get the claims file. The problem is it's a bit of a catch-22 because a lot of times the evidence is in that claims file that you need. Mm-hmm. So because of that, they're hard cases. So you don't see as many of them, although I do think it happens quite frequently. I think hail claims and storm claims, I think that some of the carriers do a pretty bad job on that and lowball and deny because they want to get out of the cases. So I see them in those areas. You see it on the injury side in car accident claims when you're making an underinsured or underinsured motorist claim to your own insurance company. And let's say they deny your claim, saying, your case wasn't worth that much, and really they didn't have a reasonable basis to do it. So you do see them, but maybe not quite as much as some other cases.
So what would be like maybe a real example of a case that you've had where an insurance company acted in bad faith, and how did it affect the client and the overall outcome?
Uh, sure, I can think of an auto case where we quickly were able to settle the third party with the other driver's insurance company for $100,000. This gentleman had a bad back injury that resulted in a fusion surgery, and when we turn around to make the claim to his insurance company says, we don't think that fusion surgery was reasonable or necessary. And without any kind of medical expert testimony or anything like that, they denied the claim, refused to pay the claim. Well, that adjuster made a mistake. And as we litigated the case and it came out that we ended up getting the claims file, we found out that adjuster did not do his due diligence. They did not have enough evidence in that file to create a reasonable basis for denying the claim. And not only did they pay for all of my client's damages, but they also paid an additional amount for more or less what would be punitive damages. Now, we settled the case, so it wasn't as if they wrote punitive damages on the check, but they wrote a check for more than the claim was worth for committing that tort of bad faith.
Wow. So it's bad faith. It's a serious allegation.
It is. It
Yeah.
is. It can be challenging to prove, but if you can, that's when the insurance company gets really afraid. I mean, it's not a secret that we're in a climate right now where people don't like insurance companies. You see a lot of just public sentiment against the insurance industry right now. So I think the insurance company, they get very afraid if you're able to actually make a bad faith claim because they're worried about what a jury will do with that.
How does that work when you want to make a bad faith claim? I imagine you got to have a lawyer do it for you. Like, what does that process look like if someone feels that their insurance company is acting in bad faith?
Yeah, I think there are some, car accident case or some cases that maybe you might be able to get a decent result without a lawyer. I've never seen a lay person or a person without an attorney bring a successful bad faith claim before. In Wisconsin, normally what will happen is you're normally bringing that bad faith claim next to another claim. Like, let's say that car accident case, you're bringing your underinsured motorist claim. So just the value of your case. And then you also have a claim for bad faith. So there's normally two cases, like a breach of contract for failing to pay the claim. And then we think that how they handled the claim was just above and beyond, let's say punitive, and was this bad faith. So you're normally bringing two distinct claims in your lawsuit. And what will happen in that case is the defense will file a motion to bifurcate and stay. And what that means is to split your case in half and to put your bad faith case on ice until they can deal with the first part of your case. The bad thing is we've got case law saying that this is the preferred way to handle it. What they hope is going to happen is you are going to run out of energy. And at the end of the first case, are you really going to litigate a whole nother case? I will tell you it works. People do get worn down by the litigation process. And then they wanted to settle both of their cases instead of just settling their breach of contract case, let's say in that underinsured motorist claim auto example that I used. So they are very different. In most cases, you are going to have to put your bad faith case on pause while you deal with your first case first. But there are situations and there are exceptions to that rule where the judges will let you get around. In the cases where there's especially egregious bad faith, sometimes the judge will let you handle both cases simultaneously.
Yeah, I guess I could get that. I could understand that. These things can drag on for a while, and once you get a settlement that you're happy with, or a decision that you're happy with on the one, you might not want to pursue the other anymore.
So that's what they're hoping, right? The flip side of that is they often have to hire completely different legal counsel for that to represent the insurance company and their own interests. So normally that's not the same defense lawyer, and you can use that against them. So if you can make that claim of bad faith, you can in some ways speed up your first case, get more value on your first case, because they're going to have to hire a whole different lawyer to represent them on that bad faith case.
Oh, wow. Are there any consequences to these insurance companies when they are found guilty of bad faith?
I mean, ultimately, the jury, the Department of Insurance can get involved too. Although, again, we don't have any control over when the Department of Insurance gets involved. They do monitor these things. They could take civil actions against the insurance companies, but really, it's hitting them in the pocketbook with a jury verdict. That's really the way you can hold them accountable.
Mm-hmm. Is this something another thing that you recommend getting a lawyer involved quickly?
Yes. Again, getting that evidence documented as soon as possible is really, really important. And making sure that the insurance company knows we are making a bad faith claim. You need to preserve all of your evidence as well, so that claims files don't get lost, so that emails don't get deleted, things like that. So putting that litigation hold so that they're required to hold all of that evidence is really crucial.
Okay. So is there like a time limit on that you have to file something like that by?
Yes. So most injury cases in Wisconsin are 3 years. Breach of contract claims are 6 years. Bad faith is unique. It is only 2 years. So you only have a 2-year statute of limitations to bring a bad faith claim against the insurance company. So it's a tighter timeline than most other cases.
Still a decent amount of time though. So you should be able to get
Yep.
something together by then, I would think.
Correct. But it's not as if, well, you can. I mean, if I had to file a bad faith suit today, I could. Would that be ideal? No. To really properly work your case, it's ideal to have a couple months to really research the case, do your homework, prepare the case before you put the case in a suit, and you're going to get a better result. So I wouldn't recommend waiting to the last minute, but you're right. 2 years does give you enough time to hopefully do what you need to do.
All right. Well, that's it for today's episode of Benson on Injury Law. To learn more about Paul Benson and how he helps Wisconsin clients stand up to insurance companies, visit paulbensonlawfirm.com. Don't forget to subscribe, leave us a review, and like our videos. We very much appreciate it. Paul, I always appreciate talking to you. Thanks so much for being here.
Yep. Good to see you. Thanks, Kevin.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.